Hello, everyone, and thank you all so much for joining us on our weekly webinar. Today, I am joined by Attorney Powers, and we are here to discuss what you need to know about the E-2 visa. And just some quick background on our Attorney Powers. She has been licensed since 2008 and founded her firm back in 2009. She is also a board certified immigration and nationality attorney. Attorney Powers, do you want to go ahead and take it away?
Sure thing. So the E-2 visa is something that's very popular because it's an opportunity for individuals to take control of their destiny and invest in a business or be an employee of a business here in the United States. So there's different E-visas, but we're going to talk predominantly about the E-2. So the E-1 is substantial trade in goods. E2 is substantial trade of amount of money and direct operations. And E3 is Australian specialty occupation workers. So when you hear E, you could get confused, like which E, 1, 2, 3, but we're talking about E2 today. And here at Powers Law Group, we've done a lot of different E's and E2s as well. And basically, this is a great opportunity now that the borders are starting to open the last year or so, and more free flowing of goods, and where everyone's trying to like make up for lost time, and also just sort of try to fix some of the supply chain issues and sort of just look for new opportunities, right? There's been a lot of great reevaluation, and there's still a lot more movement of people, goods, and things. So if you are a member, a citizen of one of these countries, and this constantly can change, but it's always good to look at the list at the time of the moment you're looking at it. You can just pretty much Google E2 countries, and you can see the list that has the countries that have treaties. So basically, if you are a member, a citizen of one of these countries, and it might not be you, it might be your spouse potentially, then you could conduct and invest in E2 here in the United States. And so we've been making, some of these treaties are from the 1800s actually. And some of these were added only just in the last few years. So the E2 treaty investors, they are allowed, and that allows the national of a treaty country to be admitted to the US when investing a substantial amount of capital in a US business. Certain employees of such a person or a qualifying organization may be eligible for this classification as well. So who can file? So general qualifications, if the treaty investor is currently in the US in a lawful non-immigrant status, what we would do is we would file a Form I-129 and request to change whatever status they're in into an E2. Sometimes they might be on a B1 or B2. Sometimes they might be on an F1. They could be in various things, but basically the E2, just to let you know, is a non-immigrant visa. So if the desired employee is currently in the US, the qualifying employer may file an I-129 to request a change on the employee's behalf. So this could be for the investor. This also could be for the employee. But to qualify, the treaty investor must be a national of the country for which the US maintains a treaty, right? To have invested or be actively in the process of investing a substantial amount of capital in a bona fide enterprise. And we can go into that a little bit more, and then seeking to enter solely to develop and direct that investment enterprise. So when we talk about the invested, it means like you would have already put the money in, invested, or could be in the active process. You've already shown that you've put some investment in and you're continuing to do so. And substantial amount can really be determined based on the type of enterprise it is as to how much is needed for it to be substantial. So investment in the treaty investors' placing of capital, including funds and other assets, have to be at risk in the commercial sense, with the objective of generating a profit. So that's the goal, right? Like most businesses. The capital must be subject to partial or total loss if the investment fails. So it's not to appear as if you have nothing to lose. Like in all businesses, most businesses, I mean, I've been a business owner for 13 years. There's reward, but there's also a lot of loss potential. And so that's, not everyone goes into business because of the risk factor, but the reward can be really great. And so you have to show the funds have not been obtained directly or indirectly from a criminal activity, which means you have to show where them funds came from. If they were gifted to you, you just have to show the paper trail. If they were earned over many years, and show the taxes and where they came from. In some countries, there's not as much of a quote unquote paper trail. So it can be a little bit difficult to show where did the money came from. That can be a problem if there's not much documentation as to the source of funds. So the substantial amount of capital is a substantial relationship to the total cost of either purchasing an established enterprise or establishing a new one. So it's all sort of proportional to that. And is sufficient to ensure the treaty investor's financial commitment to successful operation and of magnitude support the likelihood that the treaty will be successful to develop the enterprise. The lower the cost of the enterprise, the higher proportionally the investment must be considered substantial. So in general, they also are looking to make sure that you have enough funds in addition to the amount you're investing to make sure that you have enough to survive and live off of, because they know that you don't always make enough funds initially in the first year, and that you would need to be able to have enough savings to be able to use that as you're trying to make a profit, usually in your first couple of years. So another note is that we've seen usually the smallest amount of investment be around maybe 40,000 or so. That's usually something for a professional service industry. But like if you were buying a grocery store, a hotel, or some type of standalone franchise, generally it's going to be a lot more. And so when people ask, well, what's the minimum? Well, we say it's really depends on the business. And like I said, the least investment we've seen is around $40,000. Now, it can also vary from USCS adjudicating to each consulate adjudicating. And that's where it varies as well. So you also want to know the location in which is adjudicating your petition. So what's needed to file? Well, in general, the immigrant is going to need to show the detailed job description of whether they're going to be the employee or they're going to be the primary owner. As an owner investor, you want to show that you have business acumen, you have the skills needed for the type of business that you're going to be investing in. As an employee, it needs to make sense that your line of business, that you have the skill set to do that. So your educational professional achievements will need to be in line, identification and immigration documents. If you've ever been in the US before, being able to establish that you never overstayed, that you've been in status and you're eligible for non-immigrant visa. Your I-94 can be critical as well, and your valid passport and visa stamp. So previous immigration approvals and notices or denials would be helpful to have as well. Now, you as a foreign company, so you would want to show here in the US that you've been, well, what we generally do is we have you keep like an Excel sheet or some type of documentation that you can show all the funds that you put into the business. Now, if you bought a pre-existing business or a franchise, it might be a lot easier to demonstrate how much was put in the business. But if you build up a business from scratch, usually there's going to be a little here and there expenses that are going to add up. So we generally say is try to get a credit card or a bank account that you could say all of these expenses that went through here were for investing in this business, as well as you can have the Excel sheet and you can say everything that was put in this business, this is part of our investment. So you would show the wire transfers of where the money came from, to start up that investment in the bank account, your annual report, company formation information, business registration, certificate of incorporation. If you have a commercial lease, which you probably do, a short-term or long-term, unless you own the building, promotional marketing literature, all those costs as well can be part of the investment, contracts, invoices, potential business that you have waiting for you to open is wonderful. Photographs of the business showing your office location or your restaurant or your hotel or store or service, and your tax returns as well. So again, you could be buying a pre-existing business or you could be making one up from scratch. And a lot of times people like franchises, and sometimes people like to start a business that they are familiar with in their home country as well. So how do you file? So you file the I-129. If you're filing here, you file the I-129 and you complete and sign it. You submit all the applicable fees, and then you submit all the required evidence, which is basically to meet all of the elements that we've stated before, that you have the source of the funds is substantial, and we also generally show a business plan. And again, knowing your post or who's submitting your E-2 to is very critical. Some locations want a CPA certified 5-year plan. Some have very peculiar little things that they like to see. Now, how do you obtain it if you're outside of the US? Well, this is where generally every country that's a treaty holder will accept the E-2s. There's also countries that in the past have been open to third country nationals, Colombia, for example. But it also depends on how they are doing at the time. So it's always good, that could be constantly changes at the last minute. So you can, you need to double check which countries will process your petition. So a request for the E-2 may not be made on Form I-129 if you're physically out the US. So then you should refer to the Department of State website. It's generally a DS-160, a non-immigrant visa. And then if that country has the part of the treaty, they usually have a lot of specific instructions on how to submit it. They might say it can only be this many pages of a PDF and submit it here, or have a binder, or do this or do that. So it's a little bit of a different process. The other thing that makes consular processing a little different than doing it via USCIS in the country is one thing, USCIS, you can file a premium processing, $2,500, and get the decision within about 3 business weeks. It could be a request for evidence, or it could be approval. But the other thing about the consular processing is that you actually can talk to the officer. The officer can ask you questions about the business and actually have more of a conversation with you. So that's why it's important to be prepared for and have be prepped for the consular appointment. Now, a lot of people are saying, well, how long do I get to stay here if I do the E-2? Well, it really depends on the country of nationality and your reciprocity. Some countries have a 5 years, some have less so. Mexico recently increased their stay up to 5 years, but you have to ask and request it. And so that can be very wonderful, because then you don't have to renew it every year or 2 years under the lower validity periods. So if you have 5 years, that gives you a little bit more breathing room to get that business going, to hire employees, to figure out what you're doing. So by the time that you have to do the renewal, that you will have a lot more proof of your business success. So fun fact, there's not a limit to the amount of extensions you can do. I don't know what the longest I've seen, but I think some people have had them for 10 years or so. Generally what happens is people are trying to move to a green card in some respect. This is a non-immigrant visa. So it could be that the company sponsors them in the perm process for a green card, or it could be that their spouse who's able to work gets sponsored for a green card, or it could be a child trust petitions for them. So usually 6 to 10 years is just enough, if not less, to be able to convert to another visa. Maybe they upgrade to an EB-5, or maybe they just simply move on and leave. But this is an opportunity to be in the US and can sometimes create a pathway for more stay, even though it is a non-immigrant visa. The other thing to note is that you don't have to stay in the country. This isn't one of those having to maintain a residence or anything. The biggest point is that you're keeping the business going. So if you have other business ventures in other countries or locations, you can be coming and going. And what's really important when you submit the E-2 is that you also make a statement that you have the intention to depart once your status expires or is terminated. Now, if you happen to have an alternative motive to stay in the US that doesn't conflict with non-immigrant status at the time, then that's fine. And we see that happen a lot, but it is important to maintain that non-immigrant intent. So key point is that you still need to be admissible. So if you have any DWIs, that could be a problem. If you ever have any certain criminal matters, if you ever make a misrepresentation or lie to the government, this can also be a problem. And do note that you can, for family, you can have your spouse and you can have children under 21 who are unmarried, can be dependents on this. So you can do a change of status from with I-539 if the individuals are here in the country to seek that change or extension of status. And the E-2 spouses can work, and they actually have made some changes where you don't need to file the form I-765 recently, actually. And so that is something that was in the last 5 or 6 months or so. Now the E-2 investors and employees may travel and will generally be granted automatic readmission. But if you needed, you would need to have your E-2 renewed so that you can get those extensions for further validity. What's important to note is that your family and you, the principal, might get out of alignment on your extensions. And so you just need to keep an eye on that. Also keep an eye on when your children turn 21, because they won't be able to have more validity after 21. They'll have to switch to another visa. Also note that your validity of your passport can impact the validity of the I-94 and your visa stamp, so it can get very complicated. So keep an eye on ages, passport validity, and when the E-2 is going to expire. So we've helped individuals from dog grooming to tax professionals to daycares and language. It's been so many, a variety of E-2 to restaurants, to food truck. You could run the gamut. And the other thing that's really good to note, there's lots of great resources. The SBA has a lot of great resources, consulting for small businesses. Also, like tapping into some of those other programs out there of business owners and chambers of commerce. I, as a business owner and community leader in that space, and wrote a book about running a business, also enjoy these types of conversations and advice. You really need a team. You need an immigration attorney, you need a corporate business attorney, you need CPA, and you need some other advisors. It's not just a one size fit all. You really need to make sure that you surround yourselves by and create a team that can help you succeed. Business can be difficult in any country, and if you're new to the country, it can have its challenges. So those are just some of the things to be aware of, but it is a great opportunity to be able to come to the United States and to be here for a certain period of time and potentially find a pathway to stay here even longer. So that's a quick summary of the E-2. If you have any questions, feel free to reach out. Daya, how can people stay in touch with us?
Yeah, of course. So if you guys want to stay connected with us, you guys can join us live every week on Wednesdays. We do these live webinars. We're also on all social media platforms. We have an Instagram, a Facebook. We also have Twitter, and we are on TikTok. And if you see here, all of our usernames can be found. We also have a newsletter that goes out bi-weekly. But thank you all so much for joining us today. And go ahead and join us next week for our next webinar. We will be discussing a specific FOIA, just giving you guys some more information on that. But thank you all so much for joining us today, and we hope you have a good day.